Hello, ladies and gentlemen. Welcome to Chapter 6. This is going to cover arrest and use of force. Pretty interesting chapter, especially now with what's been going on in our society recently, where there have been protests involving the perspective or actual, or perceived or actual excessive use of force involving cases. Now, I said perceived or actual. Sometimes what happens is the public doesn't really understand the legality of the use of force. So when I say the legality, I'm referring to whether it is legal or not whether it is moral or not. It used to be legal for police to board a bus and pull a woman off of it and arrest her and use whatever force to make that happen because she chose not to sit at the back of the bus simply because of the color of her skin. We call those people heroes, even though that was a violation of the law, and the law allowed for that person to be arrested with an appropriate level of force. So again, I will touch on the morality aspects of it, but we'll also touch on, talk a lot about the legality of it. Some people have a problem with the level of force used by police officers within the limits of the law, as do I. Sometimes I think that the law is too liberal. This is my opinion, not a fact. Some of you may disagree. Some people, the law, I think the law can be too liberal in the allowance of the level of force that is used and supported, within the law, where an officer can't be sued or will not be held criminally responsible for his or her actions involved in the excessive use of force. One of the things I do is I review uses of force for prosecutors and for plaintiffs' attorneys and so forth, involving whether the force was reasonable or not. So with that said, here we go. For force to be used, it must be we must have a detention, and so or whether there is a Fourth Amendment seizure. So if a police officer uses any level of force, that is considered a Fourth Amendment seizure. For instance, there was a recent case that came out. It was a couple of years ago. I don't recall the name of the case, but a guy was running from the cops. The police were chasing him. He had not been placed under arrest yet, simply because he had not, submitted to their authority. And while he was running, he pulled a gun and shot himself. And the family of the person who shot himself sued the police for excessive force. So the first thing the court looked at was, if the police use excessive force, all we have to do is start with, when did the seizure actually occur? Well, no seizure actually occurred, so the police were actually incapable of using excessive force. He shot himself. Now, if the police would have caught him and then shot him or something to that effect, maybe, but without an actual Fourth Amendment seizure, you cannot have an excessive force case. So, for instance, if a police officer walks up to someone and says, "Hey, can I speak with you?" or "Would you mind coming with me?" or asking a question, that's a voluntary contact. There is no seizure there. Now, let's make sure we understand what a seizure is. A seizure is, it happens when a reasonable person would not feel free to leave. And that's a reasonable person. So someone who is raised in a way that says you always submit to the authority of the police, or if they ask you a question, always cooperate, they may not feel that they're free to leave. But that doesn't matter. It's would a reasonable person feel free to leave. If you felt like, "Hey, can I talk to you for a minute?" a reasonable person should say, "Well, he just asked me a question," and the answer is, "No, I don't want to talk to you. I think I'm free to leave." Now, if the officer comes up and says, "Hey, give me your driver's license," or "Stop," or starts yelling, tone of voice actually matters. Again, it comes down to, would a reasonable person feel free to leave? So once the seizure actually happens, we'll say for a traffic stop for not wearing a seatbelt, once that happens, you've got, we'll say, a traffic violation where you're just on the side of the road for a few minutes. That's a very low level of seizure, and therefore not a lot of protection there. You just need, hey, I need to see the guy's shoulder and see that he doesn't have a seatbelt on. That's really, and there's not a lot of protection there, as in, hey, the Fourth Amendment stepping in here and saying, "Oh, no, we can't do that." Now, so they might get, at best, a trial with a judge, no jury, very quickly to say the officer said he did it, and then that could result in a conviction, and of course also justifying the initial detention. Now, if the government goes even further, the greatest level of Fourth Amendment action, seizure, would be the death penalty. So if the government wants to put somebody to death, they can do that. They must go through a lot of court processes and appeals and so forth before they can put someone to death. All right, so the greater the seizure, the greater the Fourth Amendment protection. And arrests are only one form of seizure. Use of force is also a seizure. If someone's running from the police and the police shoot them in the back while they're running, that is considered a seizure even before an arrest is actually made. And it's okay sometimes for an officer to shoot somebody in the back if their escape could result, is likely, more likely than not, as in the officer has probable cause to believe that the subject's escape would result in serious bodily injury or death. That would justify the use of force. So, for instance, if there was a murderer in prison that tried to escape, and the only way to stop that murderer from escaping would be to shoot him in the back, then that would be an acceptable level of force. If there was an active shooter who, let's say, shot 10 people, gave up, threw his gun down, and then said, never mind, I'm going to run, and that person tries to get away, and the only way to stop that person is a bullet, then that would be an acceptable level of force as well, even though the person is no longer armed. He's already shown the propensity to kill numerous people, and if he's allowed to get away, there's a good chance he will rearm himself and kill more people, so that would be acceptable. But if somebody gets pulled over on a traffic stop, this happened to me quite a few times, they jump out and run. Well, it'd be a very effective way to stop them from running if you could shoot them, but you just can't do that because there's no, probable cause to believe that they pose a significant threat of serious bodily injury to others if they happen to escape. So you just got to chase them or let them go, catch them later, whatever the case may be. Let's understand what a seizure is. A seizure is an intentional action by a government agent, police officer, sometimes probation officer, so forth, that restricts someone's freedom of movement. Okay, so it has to be intentionally applied. So, hey, stop. That's an intentional verbal command for someone to stop. And they submit to that command. That means that person is now seized. If a cop comes up behind you and turns on his blue lights to get around you to keep going, that's not an intentional seizure. You may have to pull over for a couple seconds to get out of the way, but that's not a seizure. But if the police officer pulls over a car, that is a Fourth Amendment seizure and is covered under the Fourth Amendment. So the only way an officer can do that is have probable cause or reasonable suspicion of criminal activity. So, again, it's intentional application to restrict someone's freedom of movement. And again, the standard for that, when we talk about developing probable cause is based on articulable facts that would lead a reasonable police officer, not a reasonable person, reasonable police officer to believe that a crime has been committed and that the person being arrested committed that crime. Because a police officer has special training, like able to detect if people are armed or knows what drug activity looks like, and those are experience and training of things that the police officer can take into consideration. When it comes to a detention, it's not a reasonable police officer, it's a reasonable person. A normal person who may not know about the law, would they feel free to leave? If the answer is no, then that person has been detained. And that detention is okay as long as there's reasonable suspicion or probable cause. Right. An arrest is defined as taking the person into custody against his or her will for the purpose of criminal prosecution or interrogation. That's the technical term, but police don't take people into custody for interrogation. There's something called the Fifth Amendment, right against self-incrimination. So it's okay to take someone into custody as long as there's probable cause to believe that they committed an offense. And then you interrogate them, of course. You read them the Miranda rights, and if they want to talk, they can. Okay, so again, there must be probable cause. Taking someone into custody for the purpose of interrogation is actually kidnapping unless you have probable cause to arrest. 4 elements of an arrest: seizure and detention, the intent to arrest, the arrest authority, and the understanding of the individual that he or she is being arrested. I like to tell war stories. So I pulled over a car one time, and he stopped on the railroad tracks somewhere near Lake Charles, or almost on the railroad tracks, where I actually had to stop my patrol car on the tracks. And I almost got out of the car. I got one leg out, and I said, these tracks are inactive, so I don't have to worry about it. If I hear a train coming, I'll just move the car anyway. So something told me, you know what, don't do that. So I got on the loudspeaker and said, hey, move your car forward a little bit more. So he moved it forward, and I pulled up, and I got about 10 feet off the tracks, enough if there was a train. But I thought the tracks were inactive. The guy gets out of the car. When I told him to get out of the car, he was drunk. Failed the field sobriety test, strong odor of alcoholic beverage on breath, all the probable cause I needed to make the arrest. So I intended to make an arrest as a police officer. I had the authority, but we had a problem with the understanding of the individual that I was placing under arrest. Because, I told him, turn around, place your hands behind your back. You're under arrest for DWI. He thought I said run like hell, and he ran like hell. I already had my handcuffs out. And so I took 2 steps to chase after him. I fell in a ditch, dropped my handcuffs, so I had no handcuffs. My flashlight came out of my gun belt, so I had no flashlight. And then I'm chasing the guy, and he goes into this big abyss of bushes, and I'm like, I'm not going into that. And at the time, to overcome active resistance, you could pepper spray. And it's an agency policy thing, but it's not unreasonable to use pepper spray to get somebody who's running away from a police officer. Sometimes it's okay to use a taser. Again, we'll say different levels of force based on the agency policy and the situation at hand. So I tried to spray the guy. Anyway, he got away from that, and then I kept chasing him, and he jumped over a fence, and finally he went around the house to the left. I went around to the right because I thought I might be able to cut him off. Well, he was actually doubling back. I don't know if he was going back to the car, but he was running straight at me, and I screamed, "Get on the ground," and he didn't comply with that either. So as I was backing away, I continued to spray him, and finally he fell to the ground after pretty much a whole can of pepper spray. And I placed him under arrest. At that point, he understood that he was under arrest. And I call him for backup, and I'm choked up because I got all this pepper spray that I'm breathing too, because it doesn't just go on him. And anyway, my backup's like, where are you? And I tell them where I am on the radio, and I'm out of breath, and I'm choking. And they say, "Oh, shine your flashlight so we can see you." Of course, I have no flashlight because I dropped it. And I've got no handcuffs to handcuff the suspect. So anyway, I scream at them. They finally find me and give me a set of handcuffs. But while I was running the whole time, I heard the train horn. So my car would have been completely destroyed had I left it parked on the tracks. So moral of the story is, don't park your car on the tracks. But anyway, those are the 4 elements of an arrest: the seizure and detention, intent, arrest authority, and understanding that the individual is under arrest. A warrant is needed almost always. I say almost always. Actually, the Fourth Amendment has no exception to the warrant requirement. A warrant is required. But most arrests are made without a warrant because there's exceptions to the warrant requirement. We'll go over those. But if a crime is committed outside the officer's presence, then a warrant must be obtained. When I say outside the officer's presence, most people don't see a police officer and then commit a crime where the officer's own eyeballs actually see it. Usually the officer arrives in very close proximity to the commission of the crime, discovers the person who committed the crime, the person's still present, and then they make the arrest. For instance, if I got caught walking down the road with a stolen bag of Skittles and that I had in my pocket, I could be, they found me with the Skittles after fitting the description and so forth, they would most likely go ahead and place me under arrest without a warrant at that point. Book me into the jail, and then if I wasn't, and then in compliance with their agency policy and requirement to get a warrant, they would get a 48-hour warrant within 48 hours if I wasn't released, or just give a summons or whatever. But that's an agency rules, but generally a warrant is needed. So the police can't just come up to me 6 weeks later and say, "Oh yeah, you're the guy in that surveillance footage." What they would have to do at that point is say, "Okay, we have probable cause to believe that Steve stole these Skittles 6 months ago. We need to go ahead and get a warrant for that. Get a warrant and so forth." Or just issue a summons where an arrest is not actually made. They're just given a summons in lieu of arrest, or a ticket, basically. All right, understanding. So what goes in a warrant? There's 2 parts to it. You have an affidavit and you have the actual warrant. The affidavit is an application. It's, "Hey, Judge, I think I have probable cause, and I wrote down all these articulable facts that lead a reasonable officer to believe that this is a person who committed the offense." So again, it's articulable facts, not conclusionary statements. For instance, I worked a case at one of the casinos many years ago, and a man reported that somebody tried to rob him. So you don't write down somebody tried to commit a robbery, because I don't know if somebody tried to commit a robbery or not. But I did write down in the affidavit, someone told me that someone had committed a robbery, and that was the truth. A man said, "Hey, Trooper Thompson, a guy tried to rob me." Okay, so I write that down, because he could have been lying. So if I'd have said a man tried to rob another man, that would have been a conclusionary statement that I did not actually see with my own eyes. So again, you put articulable facts in there. And I wrote down everything that the man reported that he said. And then I wrote down what I saw in surveillance footage. And then I wrote down how I tracked the guy down, and how I identified him, and how he was picked out of a lineup. And so those are all articulable facts. And you put all those articulable facts together, and it leads a reasonable officer to believe that there's probable cause. But this guy had gotten away. So anyway, I just go take all those articulable facts in the affidavit, which is limited to what's called the four corners rule. Nothing outside the affidavit can be considered. And present it to a judge. The judge said, I believe there's probable cause here. Now, in all fairness, I must warn you, I've submitted a lot of warrants to judges. Never one have I had turned down, search warrant or otherwise, not a single one. So I'm batting 1,000, 100%. That's mostly how it goes. Officer typically doesn't present a warrant to the judge without, believing that without probable cause being there. And, maybe some judges sign those warrants without adequately reading them. I've seen some pretty bad warrants that got signed by judges that I don't believe should have been signed. They shouldn't have never even been submitted to the judge. Anyway, probable cause consists of the affidavit and the warrant. So the affidavit is the application, and the warrant is the command to make the arrest. In a warrant, you list the criminal offense. So, like I charged a guy with attempted armed robbery because he pulled according to evidence that I had, he pulled a knife and demanded money. He didn't get any money, so therefore it was attempted and not a completed offense. But you must look at the law and say, okay, what does the law say? What are the elements of the offense? Remember, I talked about running a red light, where the statute doesn't just say running a red light. It describes exactly what you must do to violate the law. That's the same thing with robbery, homicide, so forth and so on. So, I have to write down the articulable facts that show that the offender or the suspect actually violated the offense and committed the elements of the offense. Like I've got another affidavit in front of me where I charged a guy with aggravated flight from an officer. He ran from me on a motorcycle when I was chasing him, and you got misdemeanor flight and you have aggravated flight. Well, to meet the statute of aggravated flight, what you have to have is 2 out of 6 elements of the offense. So there's 6 possible things that a person can do that would turn it from, if you meet 2 of those, just 2, it turns it into aggravated or felony. So in this particular case, one of the elements was to exceed the speed limit by 25 miles an hour. I estimated his speed at 160. My patrol car was doing 130 miles an hour. It was a 70 mile an hour zone. And he was leaving me behind on the motorcycle. So I'm doing 130, which is 60 miles an hour over the speed limit. He's going even faster than that. So that's one of the elements. He ran a stop sign, and one of the other of the 6 was to disregard a traffic control device, which is a stop sign or a red light or something like that. Another one was running off the roadway. Well, he did all 3 of those, and I think there's three more, like causing a crash or something to that effect. I can't remember what they all are, but that's why we look at the law and see. I looked at the law, made sure that I saw he had violated aggravated, not just misdemeanor, and so I got a warrant for him. He actually got away. I got a warrant for him and ended up getting him to turn himself in from Texas by establishing probable cause to identify him because I got his license plate number. So who issues a warrant? It's signed by a judge, so a neutral and detached magistrate. If a judge is not neutral, then they shouldn't be signing a warrant, like if they're related or somehow personally involved with the victim and so forth. Pardon me. Okay. Again, about 95% of arrest warrants and search warrants are done without a warrant. So the situations where you can arrest without a warrant, felonies or misdemeanors committed in the presence of the officer, crimes committed in public places, and when exigent circumstances are present or there is a danger to the arresting officer. So an exigent circumstance, felonies or misdemeanors committed in the presence of the officer, just, the officer's in close proximity and time and location to the offense and can make an immediate arrest, that's okay. Another example is, or an exigent circumstance would be something like if you had a domestic incident and you showed up and a man had just beaten his wife and she's black and blue. Well, you can go get a warrant, but what's going to happen while you're going to get the warrant? She's going to get hurt. There's an exigent circumstance where an entry into the home needs to be made. Make sure she's okay. Probable cause is established. He's got bloody knuckles. She's got a beat up face. She says he hit her. That's enough to make an arrest with probable cause and without a warrant under exigent circumstances. Understanding making an arrest in someone's home. So the rule is, if a person gets arrested, or if you have a warrant for someone and they're in their own house, you can actually go in that house without a search warrant, find the person and arrest them. So like if I didn't pay my traffic ticket, you can enter my home and arrest me with that arrest warrant only. But if I'm hanging out at my friend's house, you can't just go in my friend's house and arrest me with that arrest warrant only. You have to get a search warrant for the actual residence. So the only time that can happen was when there is exigent circumstances. So let's say I have a warrant for being a terrorist. I'm Osama bin Laden. We're not going to wait on the warrant if you find out I'm actually in the house. Just go ahead and serve it because of the exigent circumstance. Waiting on the warrant could cause other people to be killed. Things that the police can do after an arrest: they can strip search the suspect, search the area of immediate control, use handcuffs. Handcuffs are not always, or they're never required, but they're a good idea. But sometimes I've arrested people who are disabled, and it just wasn't safe to put them in handcuffs. I mean, I've even arrested somebody in a walker. Please don't judge me, but hey, she was very intoxicated. So, monitor the arrestee's movements and search again at the place of detention. Before you take them, or when you take them into the correctional facility, they get searched again, and again, that's including a strip search. We typically don't do strip searches on the side of the road, only with absolutely necessary. Did have a female who stuffed finished product in her panties, and that became a problem. So, we did a strip search on that. Or we needed to do a strip search on that. So I called the female in, and we got some of the product out of her panties and then brought her in and did a full strip search at the station. Okay, here's some questions like, can the police detain a suspect while obtaining a warrant? For instance, that'd be like a search warrant. So let's say the police get a loud music call. They knock on the door, and just say, hey, I'm going to tell them to turn the music down. Well, they open the door, and then the officer gets hit with a big cloud of Colombian smoke, the strong odor of marijuana. That would give the officer probable cause to believe that there's drugs inside the house. So that a search of that house could not happen without a warrant. Police can't search a house without a warrant. Although they can detain the people inside while they're obtaining the warrant, because while they're obtaining that search warrant, they're going to destroy the drugs, and flush them, finish smoking them, whatever the case may be. So that's perfectly acceptable to make that detention. And usually how it goes is this: knock on the door, establish probable cause of search by knock and talk, odor of drugs, whatever, and then say, hey, and the officers will ask for consent to search. And the person says no, then the officer just informs them, okay, look, I'm going to go ahead and detain you while we attempt to get a warrant. Not get a warrant, but attempt to get a warrant, because no warrant is ever guaranteed. And we're going to hold this down, we're going to lock the scene down until we get the judge to either approve or deny the warrant. That's going to take a couple hours. So with that in mind, are you sure you don't want to give us consent? Some people would consider that coercion, but right now that's basically a laying out of the facts. If you want to say, hey, you can change your mind if you want to, that's perfectly okay. But it's always a safe bet to go ahead and get a warrant. Citizen's arrest. And so a citizen can make an arrest. Different states have different laws. Louisiana, the law is if it is a felony committed in the presence of a citizen, that arrest can be made by a citizen upon another citizen. But they fall under the same rules. They must have probable cause, and they must use a reasonable amount of force to effect that arrest. All right, so the use of force. There's a lot of cases out there, a lot of different situations. There's just too many to talk about. But the police must use a reasonable amount of force. So that is debatable. A lot of people argue over whether the force is okay. For instance, Tamir Rice was a 12-year-old child playing in a park with a toy gun. Police rolled up, jumped out of the car, and shot him within just a couple of seconds. The FBI, a bunch of different use of force experts looked at it and said, yeah, it was okay. I completely disagree. I believe it was excessive force. The officers, you watch the video, it's very sickening to see, but those officers did not go to prison, and it did result in civil liability. I believe it was around $4 million for the family. But you have a 12-year-old child gone. We have cases where maybe the public doesn't necessarily believe or understand the rules and think that the police violated the rules. So those are cases where we need to understand that the problem is not with the police officer, the problem could be with the law itself. And again, I've said that the law, I think, is a little bit too liberal on allowing the use of force. Some people say it's not liberal enough, but there are cases where somebody reaches for their wallet at a crash scene and the officer shoots them because he could have been reaching for a gun, and they get completely exonerated and go back to work. I think that's too much. So Again, we have to look at each one individually to determine. Like, George Floyd was a more recent case where the officer kneeled on George Floyd's neck for roughly 10 minutes. That was an obvious, slow, methodical, brazen homicide. It was murder all day long. There's another video that has come out. I don't remember the gentleman's name that was shot. He was shot in the back while he was attempting or actually getting into a vehicle. Now, he was shot in the back, but sometimes that's okay, because if you watch the Deputy Dinkheller shooting, the deputy was killed by a guy trying to get back in his vehicle, got back into his vehicle and accessed a long gun, a much superior weapon than the deputy had, and then killed him with it. So officers are trained, and I train officers to, it's okay to shoot somebody in the back under those circumstances. So I don't know what happened in that particular case. We don't have enough information. We don't have the body cams, but, sometimes it's okay to shoot somebody in the back. And when I say okay, there's no such thing as a good shooting. It's a constitutionally justified shooting. Whether it's moral or not is a completely different story. We can talk about ethics in another class. So that's my general overview of the use of force. Again, it must be reasonable, and there must be probable cause to effect an arrest. And if deadly force is used, there must be probable cause to believe that the person poses an imminent threat to the officer or others before that deadly force can be used. All right, thank you for listening. That covers Chapter 6, and we'll see you in Chapter 7.